In this video, I am replying an important question answer, and many people also asked about such type of questions and sought our replies. The question is that whether an divorcee wife or talaq obtained wife has right to file a petition under section 12 of the Protection of Women from Domestic Violence Act 2005 and can seek other reliefs which is provided by the Protection of Women from Domestic Violence Act 2005. The answer is very clear. Such type of proceeding has initiated before the Honorable Odisha High Court, and Honorable Odisha High Court has held and decreed the judgment in case of Sunil Kumar versus Sumitra Panda 2014 Criminal Law Journal Odisha, page number 1293, and passed judgment and replied that the High Court has answered the question in affirmative, as subsisting relationship is not sine qua non for filing application under section 12. The Honorable Odisha High Court clearly stated that marriage is not to be proved strictly, and Honorable Odisha High Court replied that a divorcee wife can claim maintenance and other relief under section 12 and other sections of the Protection of Women from Domestic Violence Act 2005. It is clearly stated by the Odisha High Court. In case of under section 125 CRPC, strict proof is required whether marriage was solemnized validly or petitioner agreed person is the legally wedded wife of the opposite party or respondent is to be proved strictly who has filed petition obtaining maintenance under section 125 CRPC. But in case of Protection of Women from Domestic Violence Act, no strict proof of marriage is required. So, under the DV Act, and divorced wife and talaq obtained wife can seek maintenance and other protection order and monetary relief and medical facilities and shared hold living facilities can be obtained or decreed in favor of the agreed person as per the provision of the Protection of Women from Domestic Violence Act. Thank you very much. Have a nice day.